It's not bankruptcy because they're not bankrupt, even though they're morally bankrupt. They're not financially bankrupt.
Plain speak, yes, they lose almost all their rights, if not all their rights.
Welcome back to Parallel Justice, the podcast that dives into the crimes and cases that have dominated the national headlines through exclusive interviews with the very attorneys who fought the cases. Some of the discussion you hear today may be controversial. However, we know that silence, especially on tough issues, only enables and encourages wrongdoers. It's our goal to bring these issues to light so that we may have meaningful discourse around them. The views expressed in this podcast are those of our guests, who are experts in these areas. Their opinions are invaluable, however, they do not necessarily reflect the views of the National Center for Victims of Crime. The topics we discuss may be disturbing, and they are intended for adult audiences only. Some of these topics may also be triggering, and we encourage you to practice good self-care and seek support. I'm Renee Williams, Executive Director of the National Center for Victims of Crime, and your guide through this conversation. Now, let's start the show. Welcome back to another episode of Parallel Justice. As always, I'm Renee Williams, your host of Parallel Justice and the Executive Director of the National Center for Victims of Crime. I feel like there are two celebrities joining me today, and I've never said that on this podcast before. We have with us Jeff Anderson and Mike Finnegan from Jeff Anderson and Associates out of Minnesota. And Jeff and Mike have really been on the forefront of the Catholic Church litigation, and they have led so many of our members in this litigation. And so maybe I shouldn't have given them that much of an introduction when I'm going to say I'm going to let them introduce themselves. But Jeff and Mike, would you like to introduce yourselves?
Sure. Well, this is Jeff Anderson, and it's nice to be with you and all the colleagues in our group. I have been actually practicing law. I just counted yesterday for 47 years. And I know, working with survivors now since 1982, and exclusively our firm, Jeff Anderson Associates, has been working with and for survivors now for 3 decades exclusively. It's a choice we've made, and I'm honored to be standing with the brothers and sisters in this organization devoted to helping survivors and protecting kids in the future.
And Mike?
Yeah, hi, Renee. Mike Finnegan here, and I've been working with Jeff and the other people in our firm on behalf of courageous survivors for the last 20 years that I've been here, and it's an honor to be here today with you and all the people that are listening.
Thank you. And as always, we are going to put in the show notes for all of our listeners so they can contact you, your website. So keep an eye out for that. Now, on Parallel Justice, we've talked about a lot of institutional cases. This has become a recurring theme, as it does in our line of work. But we've never quite talked about the current state of what's going on with the Catholic Church right now. So we're here to talk specifically about the case of the Camden Diocese. But let's just start at the upper end of that. What was going on in Camden, and how much did it parallel what we've seen in the rest of the Catholic Church litigation?
Well, this is Jeff, and let me really give a broader context to that question. And the context in Camden is that they filed in October of 2021 for reorganization, Chapter 11. And the context for that filing was that they are the first diocese in New Jersey to have sought protection in Chapter 11 because New Jersey had opened up a window of 2 years for survivors to bring any cause of action against the offender or any institution that allowed it to occur. And as a result of that window, the Catholic bishops in New Jersey made a strategic decision to say, we're going to go into a Chapter 11 in Camden first. That was strategic, and that was a decision made by the bishop in Camden in consultation with the Catholic bishops in New Jersey, in New York, and in particular, the Vatican. And the context of that decision in Jersey was, we want Camden to go first, and we want to set the bar there for various reasons that we'll get into. The larger context and significance of the Camden filing is also important, because it is no secret to anybody that will be listening to this program that the Catholic bishops and the religious orders across this country have now made strategic decisions to seek refuge from scrutiny and accountability by using the bankruptcy code. Chapter 11, called reorganization. Some people call it bankruptcy. It's not bankruptcy, because they're not bankrupt, even though they're morally bankrupt. They're not financially bankrupt, but they use reorganization, or Chapter 11, to get out from their liability to survivors and to escape a full measure of accountability that we know our individual jury system allows individual survivors through the crucible of the courtroom and jury trials. When a reorganization gets filed, then the bankruptcy code goes into play. And I'm not going to get into all the details of that, but a creditors committee of survivors gets composed, and we represent one of the members of the creditors committee as state court counsel. Bankruptcy firm gets hired by the creditors committee, and Lowenstein and Sandler got hired in the Diocese of Camden, who represent the committee. And that bankruptcy and that reorganization started to move at a really rapid pace. It drew a Judge Pazluzny, that wanted to put it on a fast docket, and the Catholic diocese and the Catholic bishops there and their attorneys took a very aggressive approach. So there was a great deal of early contention in that reorganization, and us at odds with the Catholic bishop, Sullivan, their lawyers, and the committee and bankruptcy council and state court council all came together and stood united and strong against them, and did everything we could to expose their desire to suppress the survivors and avoid accountability. And so when the insurers, who are well known to us, cooked up a deal with the Catholic bishop and their attorneys, they proposed a settlement to be approved by the bankruptcy court. We fought that immediately and continued to file rigorous oppositions to that, but also continued in mediation. The committee of survivors, composing of 9 survivors, and the bankruptcy firm and all the state court counsel, all of whom are experienced in this space, stood united, and we really stood strong. And by having stood united and stood strong against the diocese and what they were trying to do, and set such a low bar here, we leveraged ultimately in mediation a settlement that made a deal that was with the Catholic bishop, the Catholic diocese, and all of the parishes and entities controlled by that bishop. That would be the schools, the parishes, and the diocese itself. And the deal we crafted with them, that is the bishop, the parishes, and the schools, is that they would agree to pay to the survivors the sum of $87.5 million. The insurers, the insurance companies, are all out of that deal. And under that deal, the diocese, the parishes, and all the entities controlled by the bishop agree to assign their rights under their insurance policies to the survivors and the trust. so that the survivors and all of them then through the trust can then prosecute coverage actions against the insurance companies, namely London Market Insurers, Interstate, AIG, and Century. But those are the rough contours of the deal that got struck. When that got struck, and from that day that that got announced to those insurers, they have reacted with horror because they are now exposed in a way to pay what they have, are obliged to pay under their insurance contracts, and now are facing obligations that they've never had to face before. And as a result, that has triggered more rigorous litigation in Chapter 11 in any of these cases that have gone before.
So that was a great introduction, and it gives us a fantastic roadmap for this conversation, because I think a lot of times this is confusing to lawyers, and we have a lot of non-lawyers that listen to this, and we're trying to make it accessible to the non-lawyers. So I want to understand, keep in mind, we've spoken to Mitch Garabedian about the historical Catholic cases, but we didn't really delve in ways I think we can with you all about some of the things the Catholic Church has done to avoid this litigation, and that bankruptcy and all of the hoops you just described is a great example. But I think it's not even clear to the general public, how do they get into bankruptcy?
So these are individual actions brought by courageous survivors working with individual law firms like ourselves and our brothers and sisters that represent those survivors one-on-one. And then when there are a lot of cases, like there were in Camden, over 300, and the diocese or the religious order, in this case, the diocese, makes the choice to avoid the first trial that was coming up, or the first required disclosure of their files that was coming up, or some measure of accountability publicly and in the courtroom, then the diocese and the bishop choose to seek refuge in Chapter 11. So that's kind of the how and when it works. And what causes them to choose to go into that, we'll get into that, because we know what criterion they use that causes them to use Chapter 11 as what we call their refuge.
And now we
Renee,
usually, please go ahead. Yep.
This is Mike. I can add a little bit on the bankruptcy side of things. So the history of it was that Jeff primarily and other lawyers like Mitch Garabedian were bringing these cases individually, and it wasn't until the early 2000s that, as a country and as individual states, that they saw the need for massive changes to the statute of limitations, the time limits, and those started to get opened up and gave survivors more of a chance to bring cases and get into litigation. That the bishops decided as a strategic plan that they were going to use bankruptcy, and when there's a bankruptcy, there's basically two different types of bankruptcy. There's a Chapter 7, which is liquidation, and then there's a Chapter 11, which is reorganization. The first one, when you're liquidating under a Chapter 7, that's in simple terms is going out of business, turning the lights off, selling everything that company has. It's no longer existing. So if you take a small business that is out, selling some product, it means that they're going to wrap everything up. They're no longer in business after that Chapter 7, that liquidation is done. Business is over. The other way that companies use and do it is through a reorganization, which is Chapter 11. And so what the bishops have done is they've chosen the path of reorganization, Chapter 11. And what that means is they get to go in there, and we'll talk about the reasons why, because there's some really sinister reasons why they've used it. But they go in there, and then what Chapter 11 does is it allows that that business here, the diocese, to go in there and try and work out a settlement with their creditors, and then they're still in business afterwards.
I'd like to get into what are some of those reasons, especially the sinister ones. How do they go about this?
Well, they go into and use Chapter 11 because they and their insurers, the Catholic bishop and the parishes that the bishop controls, and all the other entities under his control, all have learned for the last decade that bankruptcy and the bankruptcy code favors the debtors. The debtors are the corporations. The corporations created the bankruptcy code and a set of transactions that favor the rich, the wealthy, and the powerful, which are the corporations.
Well,
And
and
that's
I
why,
imagine it's a way to try to remove morality as well. You're not litigating morality, you're litigating, are they poor?
and everything in the bankruptcy code treats every claim as a debt or a transaction. So the whole process is transactional, presided over by a bankruptcy judge who doesn't really work from the heart, but works from a transactional paradigm. Creditors and debtors, that's all they see, creditors and debtors. And how do we get this debtor out of reorganization, out of bankruptcy, out of Chapter 11, and back on their feet so they can continue to make money? And it was written by the corporations, and the Catholic bishops realized they are favored because they have the same alliance as them and the insurance industry. And so when they go in, they make the decision in concert with their insurers that it is to the advantage of the insurers. Why is it to the advantage of the insurers? It is because historically the values of settlements in reorganization are lower than a lot lower than what the insurers also, when they come out of reorganization, make a deal where they're off the hook for all future claims, and the bishop and its entities, once they get out of reorganization, are all off the hook for all future claims. So it is a great place for them to go to cut off their future liability, as well as pay less than they otherwise would have to if they were in the tort system.
And the history, Renee, also is really illustrates another reason, the sinister one that I had in my head, of why the bishops have used this historically. And again, it started back in the early 2000s. And what happened and what they do is that the bishops made the choice to use reorganization to cut off the exposure of their long-held secrets and their secret files from having to testify under oath. And so what happened in Portland was one of the first ones that went right on the eve of trial. It was right before there's going to be a public trial, expose everything that happened in that diocese. And to stop that, the bishop files for reorganization bankruptcy that puts an automatic stop on any of the state court litigation, pushes it all into this bankruptcy system. Camden and a lot of the others, the lawsuits are starting to move forward. And this is going on in New York as well. Survivors are asking for their secret files. So each one of the bishops have files that they have all the evidence of child sex abuse going back 50, 100 years. They keep it under lock and key, and the windows and the Child Victims Act that have been enacted in places like New Jersey that gave survivors a chance to get those documents. Survivors are getting closer and closer and closer to getting those. And that's when the bishops largely have decided, we're going to file reorganization. It stops all of that, takes all that power away from survivors. That's the really tactical, sinister reason that a lot of the bishops have used reorganization.
So reason number one that I gave was it gives them an opportunity to pay less to the survivors and thus avoid full accountability. Reason number two that Mike just expressed is that it gives them a chance to stop all litigation. in state court and all the cases, puts an immediate stop to it and turns it all over to the bankruptcy court to handle.
Mhm. And I think,
And then reason number 3 is it gives them a chance then to thus continue to hide offenders. It gives them a chance to continue to hold on to and thus hide the files that we force in litigation to be disclosed as a part of litigation that they keep on all the offenders, called the secret files and all the personnel files. It also gives them a chance also to hide assets. The bankruptcy code requires them to make disclosures of assets, of their ability to pay. But the reason we say that they use the Chapter 11 to hide assets is they do make disclosures that are required, but they always under-report and under-disclose their true ability to pay. And they hide their assets into various entities controlled by the bishop. So the bishop will file for reorganization in the corporation of the bishop, but then will have assets that he's put into each of the 138 parishes where they hold assets, investment funds, cash, and other assets that aren't in bankruptcy, but then they stop the litigation against those parishes. And as a result, then they can use a shell game and create all these piggy banks for the bishop to hide the assets. And thus, they use the code and Chapter 11 to avoid any measure of real and full accountability. And that's why there are so many in which we and the survivors and other colleagues are involved that are now so contentious, because there is a lot at stake here.
and I, for the public, you both said this, but I really want to bring it to the forefront. And then I'm going to ask a very rookie question. You both mentioned this cuts off all future litigation. So once you've entered bankruptcy, and we keep calling them creditors, but in this case, the creditors are the victims. And so once you go into bankruptcy, any future creditors have a certain amount of time to make a claim or you're out. That works in bankruptcy court, but what the practical effect is any victims who remember later in therapy that they were abused, who try to come forward, are out. Is that what we're talking about here?
Yep, they're either
In
out
plain
or
speak?
their rights are in plain speak. Yes, they lose almost all their rights, if not all their rights. And so it is the exact opposite of what a trauma-informed approach should be for survivors, and the exact opposite of what of what is best for survivors. But it is the one of the tragic things about the system is that it cuts off everybody that was abused before that bankruptcy got filed.
Well, and so that was my next big question. Is the lead-up question is the rookie question. What duty does the church have? Do they have any to say, hey, if you were a victim, you need to come forward? Do they have any obligation to tell people that they might be cut off, one? And then two, if they do get cut off, what are their chances of fighting this?
Well,
So,
the application.
You want
Go
the first
ahead,
one?
Mike.
This is Mike. The first one, Renee, there is a for every this applies for every corporation that goes into Chapter 11 into reorganization. The bankruptcy court forces them to give notice to anybody that they know about that might be a creditor. So here, like you said before, it's the victim survivors. But what we know is, unfortunately, that most people don't come forward and can't come forward. And, and there's a huge class of survivors that I've been worried about for a long time that are the ones that are young, that are really young, that have been recently abused before these entities go into bankruptcy. And, even if they read something or get notice, a kid that is still a minor or even somebody that's in their 20s, 30s, most of them are not coming forward no matter what. They're not at a place where they can do that. And those are people that are, even with notice, this system cuts them off,
So
unfortunately.
wait, there's no protection for minors, just to be loud and clear about that.
So the way that they do it, it gets a little complicated, but in my mind, they're taking away their rights.
So they're effectively nullifying both statutes of limitations and any states that have passed the Child Victims Act,
Yes,
essentially.
yes.
So how do you fight that?
You just continue to fight. It is a due process violation. The bankruptcy courts obviously have been unreceptive to our pleas that this is a violation of due process. And so far, it has not gotten up on an appeal where it has been ripe for challenging of the due process. And the reality, rights of survivors created by state law. It will ultimately get decided down the road, but the way the whole bankruptcy process works, you have to get through it before you can get it up to a court that isn't a bankruptcy court and into a district court or a state court or a federal district court and an appellate court, and has yet to get there. It will get there someday, and hopefully sooner rather than later, but that is a battle yet to be fought, and certainly one that rages as we
And I
speak.
think the tragic thing that people need to hear, and we call it the perfect case for appeal, even though that sounds horribly cold. In this case, it will have to be a case that failed. So a victim, a child who has been abused, is going to have to go through the litigation process, which is already brutal, and it will have to fail in order to fight, because you will need somebody to appeal.
Well, when they when they create these deadlines for making claims, they cut off 80% of the survivors. They cut off 90% of the actual survivors that were abused in that diocese. That is a reality. And they're required to put notices in newspapers and sometimes TV and radio and the like. But the reality is, we all know survivors aren't capable of coming forward, and most of them don't get the notices. And so it works entirely to the benefit of the Catholic diocese to cut off these rights that the legislature confers, and it is an outrage.
A kid 20 years from now comes forward and wants to sue.
So none of these so far in the 30 plus Catholic bankruptcies that either bishops or religious order have filed, none of them have had that future claims fund for more than, I think the longest was 7 years. So at the end of that 7 years, they're out completely. And so done, then all rights are cut off at that point. But if we change your hypothetical a little bit and there's a kid that comes forward within that 7 years, we'll say that that's the deadline, then that survivor, he or she would have to bring a claim within the bankruptcy trust system that gets set up. And they'd have to assert that claim within that system, but their rights are incredibly compromised, and they don't have the ability to use the jury system. They don't have the ability to do much there other than just assert that claim, say they're abused, and try and get a little bit of that money. But that's it. And then once that time limit is up for the future claims, everybody's cut off. All survivors that were abused in the past are completely cut off at that point.
The second battle line and raging literal war is against the insurance industry. And it's not just those insurers involved in Camden, but it's all the commercial insurers across the country that have been underwriters for Catholic dioceses and religious orders, and all the big insurers from CNA to Transamerica to AIG, you name it. They wrote policies. They stopped writing policies in the mid-'80s because of their exposure, but the reality is they're in these cases, and we're at war with that industry, and that industry has been in collusion with the Catholic bishops in the diocese for decades. The third battle line is against the bankruptcy bar. The bankruptcy bar, from the judges to the lawyers, to that whole industry of corporations and insurers and all of them that created the code are all sweeping or making a real significant effort to sweep all tort legal liability against wrongdoers and corporations and now Catholic dioceses into the bankruptcy code and out of the tort system. And so we're now at war with the whole bankruptcy system because for reasons we've already stated. And so the reality is that in New York, as an example of I think there are 8 dioceses in New York, 4 of which have already declared for Chapter 11, in which we're all involved, and there's 2 more likely to go. In Minnesota, when we had a window there were 6 dioceses, 5 of which all went into Chapter 11, and we're facing the same prospects in California where we have an open window now, and the same things happening any place the statute of limitations gets opened up. So make no mistake, there are several battle lines and raging as we speak, not just against the Catholic diocese and the perpetrators, not just against the insurers, commercial and captive, but rather the whole bankruptcy code that deprives all the survivors and individual survivors of so many rights they otherwise would have.
Well, and I want to talk about all of your survivors for a minute and really bring it home on the reason that I think we've moved past the question of why would we sue the Catholic Church. And I think the Catholic Church's accountability has been more than established. But I think one thing people miss and that they don't hear from survivors enough is the act of the perpetrator was one thing. The betrayal of the church, who is supposed to protect these children, is its own other thing. It's almost more painful than the act itself. The lengths that the Catholic Church has gone through to cover this and to protect priests who did this when they were supposed to be protecting the people that go to church, their flock. Do you want to talk about any of your survivors in that regard or how they're doing?
Well, that is it's a conversation that always needs to be had. And in the context of today's conversation, I think everybody that works in this space knows how difficult it is to first share the secret and then take an action as a Jane Doe, as a John Doe, and or as in their name, and how difficult litigation is. When wrongdoers, such as the Catholic diocese, seek refuge in Chapter 11, they actually cause further harm and aggravate the harm that has already been caused to each of those survivors as children. And most of the survivors that do come forward are, somewhere over, the age of 30, and they up to 80 and or 90 years old oftentimes. And the reality is that salt gets poured in their wounds by the process of a diocese seeking Chapter 11 protection. And then survivors are required to go through the rigors of making claims in bankruptcy. And while their anonymity is well protected in the process, and I'm glad of that, and I've never had, nor will we see anybody's anonymity violated in the bankruptcy process, and they have been protective of that. The process itself makes survivors feel like their voice doesn't count as much. Bankruptcy fees in these reorganization cases are staggering.
Oh, I'm sure.
Staggering. And they come out of the bankruptcy estate. That means out of the funds that otherwise would be available to the survivors, and the Catholic bishops across the board plead poverty. They say, we don't have the funds, we can't pay. And as a result, they suppress a lot of the settlements in a lot of the cases. Make no mistake about it, on the sheer ability to pay, both because they're successful at hiding assets and they're successful in convincing bankruptcy judges to not let the survivors do enough discovery to discover the assets, which happened in Minnesota. 5 of the Catholic dioceses, the judge kept the committee and our side and the survivors from doing discovery of the assets, of the true ability to pay. And as a result, the settlements that were reached by necessity were under the true value of the ability of the 5 Catholic dioceses to really pay. We, for example, discerned that the Archdiocese of St. Paul and Minneapolis had an ability to pay when you look at their liquid assets and their real estate alone and the assets held in parishes that exceeded $1 billion. The settlement on behalf of close to 400 survivors was $210 million, which would appear to be on their books as represented by them to be fair value. But when we know what we really knew and weren't able to excavate, it was a bad deal.
So Jeff and Mike, that is about all the time we have for today, but I never like to leave any loose ends open or let anybody think, darn it, I wish I would have said that. So any last minute thoughts for our listeners?
Well, I do have a last minute thought, and it's one of the most important things that can be said. And I usually open any conversation with it, and that is first giving credit to the courageous survivors with whom we and our colleagues have had a chance to work, who have found the courage and a way to come forward and share a painful secret and take some action. And to each survivor with whom we and all of our colleagues have the privilege and the honor to work, we just need to give you, each man, each woman, each person, credit for having stood up, not just for yourself and your truth, but to know that individually, by having done so, by having shared it publicly as a Jane Doe or as a John Doe and taken an individual action, wherever you are, you have also done something to protect other kids in the future and thus made the community safer. And each survivor needs to know that, and to each survivor, credit is due for protecting kids in the child protection movement. That is a reality that always needs to be acknowledged and said, and we are all privileged to stand on their shoulders. The second thing that needs to be said here and now is the creditors and the survivors that assemble in these committees, and in Camden in particular, the amount of pressure that was put on by the Catholic bishop to try to force them and jam them into a settlement was so intense, because they're obliged to speak on behalf of all the survivors. But they stood strong and they stood united, and they said, no, this is wrong, and we will fight, and we will continue to fight. And to each of them, the credit is so deserved for their courage and their stamina. And there are now at least a dozen other survivors called creditors committees that we're working with in New York and elsewhere that are under the same kind of pressure. And we just want to, on behalf of all of us working with them, give them credit for their devotion, their courage, their stamina, their persistence, and the difference that each of them make every time they stand up and share their truth and share them with each of us. And to them, we stand humbly in gratitude.
One of the best last thoughts we've had.
Thank you for joining us for this conversation. If you have any questions about your rights after listening to this show, please visit us at victimsofcrime.org. Our guests' information is also always available in the show notes. This podcast was created by the National Center for Victims of Crime in partnership with our center and affiliate, the National Crime Victim Bar Association. More information about both organizations is available at victimsofcrime.org and victimbar.org. Thank you, and please join us again next week.